Welcome to the latest episode of Gowling WLG's Listener Podcast, where we look at a range of topics trending in the legal and commercial landscapes.
Welcome to our Commercial Contracts podcast, where we're going to look at a case, bringing together a contracts lawyer who drafts contracts, that's me, David Lowe, with a lawyer who specialises in disputes.
That's me, it's Andrew Smith.
And today we're going to look at a case about a logistics contract called Kemball and Limited. So Andrew, what's all this about?
Well, it's an interesting case, David. And whenever a lawyer says it's interesting, you've always got to be slightly worried. But it's a good case because it helps one to understand some of the pitfalls of termination. It also helps with some pretty interesting drafting points, which can help you not to talk to somebody like me, i.e. a litigator, get you out of the problem before it arises.
Yeah, and I found it interesting for all those reasons. Also, in fact, it felt like a kind of contract that I might have drafted, and it felt like the kind of dispute I see our clients having, which many contract law cases you sort of looking at, well, I'd never have done that anyway. And so, yeah, this is Kemball and Limited. It's a recent case, and it's about a transport contract where there was a minimum order quantity. So it's a 3-year contract, and in each year, the customer needed to buy a certain number of jobs. And the customer decided towards the beginning of year 3 that due to restructuring, it wasn't going to be able to purchase the minimum level of jobs. And it told the supplier. And the supplier wasn't very happy, was he?
No, it wasn't. And I think seeing that it was about to lose £12 million worth of turnover to its business for the next year, it kind of was very quick and as we will talk about, too quick to decide that that was a really bad breach of the contract, which entitled it to terminate. And essentially what it wanted to do was monetize that £12 million of loss in litigation.
And I guess if the supplier, not having read the contract, that was not an entirely unreasonable reaction. As £12 million worth of business is being taken away, it's a 3-year contract. Surely the customer should be obliged in some way to finish the contract, or if they're not able to do so, that's a breach and I can terminate that. That would be a reasonable instinctive reaction if you hadn't bothered to read the contract.
Yes, or if you hadn't read the contract carefully enough, which is what this case is really about, which is you've got to make sure that your contract is drafted correctly, but also that if you're going to push the big red shiny button with termination on it, that you've really understood what your rights are.
Okay, so the supplier goes for termination and goes for claiming 12 million. How did that unfold?
Not very well for the claimant is, I think, the simple answer to that. So in relation to this case, their biggest problem was that there hadn't been a breach, let alone a breach that entitled them to terminate. But just before we go into the reasons for that, which is more your work, I'd like to talk about, the idea of termination, because it gives us an opportunity to look at a case and perhaps assist in other matters that our clients might have in relation to deciding whether to terminate and how to terminate. And really, termination can be one of 2 ways. You can either terminate for a breach so serious that it just entitles you the sort of a general right in law to terminate because it's a fundamental breach of the contract, or you can terminate because the contract itself gives you an express right to do so. They're very different things, and in this case, although actually the claimant had no right to terminate at all, it also made the mistake of trying to terminate on one narrow ground. And there was a lot of argument in the case as to whether, in fact, it could terminate on different bases. And the lesson there is, number 1, make sure you have the ability to terminate, fairly obviously. But secondly, if you are going to terminate, try and make the termination notice as broad as possible, preferably with alternatives, which, as most of us know, lawyers love. if it isn't this, it's that, and if it isn't that, it's the other. Try and terminate in a way that covers as many bases as possible, because termination is not easy anyway, and you don't want to shoot yourself in the foot.
And when you talked about those two ways of terminating, one in accordance to the contract, so that'd be your normal clause that usually says party can terminate due to a material breach or whatever. But the other non-contractual right, that general rights, you talked about a fundamental breach. I think that's what is known as, that's the repudiatory breach.
That's right. It goes to the heart of the contract and therefore entitles you to terminate. An example would be the other side declaring an intention no longer to be bound by that contract at all.
Right. So in this case, if there had been a breach, let's imagine there was a breach, and let's imagine it was a big breach, probably the claimant should have been advised, try and terminate for both reasons and preserve all of your rights to see then what unfolds, so that you're in a stronger position.
Indeed, and maybe not even just the two reasons. Lawyers love to have 3 or 4 or 5.
Well, I noticed even that the judge picked up on another reason they could have terminated for, which they didn't even plead. Indeed. So the judge even spotted lots of other options in this one. Okay, so the advice then is to people who are terminating contracts due to breach, you really need some level of legal advice to make sure you go off in the right direction and do a broad determination as you're right, but not so broad to shoot yourself in the foot.
Yeah, and talking of shooting, it is deciding to terminate is a dangerous. It's an extreme sport. So it's a bit like a Mexican standoff, like in Reservoir Dogs. If you decide to terminate and pull the trigger and you go off half-cocked or it fails to fire, the real problem is that you get your own head blown off, because essentially, if you get a termination wrong, you yourself have committed the repudiatory breach we talked about earlier, because you're saying the contract is no longer going to carry on, and the other side can claim damages over you. So it fires up in your face, basically.
And that's what happened here, didn't it?
Yes.
Because the judge found that there was no breach of contract, and therefore there was no entitlement to terminate for any reason whatsoever. And I found that interesting, because before I read the case and before I read the contract it refers to, I was sort of instinctively expecting, well, if there's a minimum order quantity and there's a breach of that, well, that's a breach of contract, because normally in a contract with minimum order quantity, it says this is the minimum order quantity in a year, and it will say that's an obligation of the contract. And therefore, if you fail to order that quantity, that is a breach. Now, there might be a debate whether it's material or not, or a fundamental breach, but it is a breach. What I found really interesting about this case is actually the minimum order quantity clause wasn't a simple one which then said, and that's a breach. It said, if you fail to order so many jobs, which is the wording in the contract, then there's a formula that then worked out how a shortfall payment is calculated. So a really nice, clear, well-drafted payment mechanism. It said, if X happens, then you'll pay us Y. And the customer in this contract, who had said, I can't buy enough, had volunteered to the supplier, hadn't he?
Yes.
That hey, I realise I owe you some money under clause blob to pay under this formula, but I'm not in breach. And the judge read the contract as a whole, and said, yeah, that's exactly what was intended. It makes sense to me that you've anticipated this thing happening and you set out a consequence, and therefore, no, supplier, I disagree with you. There is no breach of contract. The mechanic works and you're owed a shortfall amount of whatever £1,000 that will be.
So essentially, the contract drafting saved the customer from a breach of contract situation, which in normal circumstances probably would be. So it does, and you know I don't like to say this, David, it does show your value in some shape, manner or form.
Well, I do my best to keep my contracts out of your hands, Andrew, after all. Yeah, and I think there's an interesting point, because firstly, there's a very clear payment mechanic. And I think a key drafting point for everyone on this is if you've got a contract with minimum order quantity, say what happens if it's not reached, because it makes it so much easier. I had a recent dispute where it did say, if you fail to reach the minimum order quantity, then you will then have to pay us the full amount that you would have paid us anyway. And then when the customer tried to dispute that one, they had nowhere to go. So be clear about what the consequences are. Be clear whether it's a breach or it's, in this case, whether there's a payment mechanic. The other thing in this contract which really nailed them was the fact they used the word sole and exclusive remedy. So not only is there a payment mechanic, it expressly said, and this is a sole and exclusive remedy. And the judge seized upon that, didn't he? He said, there you are. He makes the point. This is intended to be what happens when this happens. Trying to claim breach is rubbish and it's irrelevant.
And indeed, even if there had been a breach, which there wasn't in this case, termination is a remedy in the law, and therefore if the sole and exclusive remedy was this payment mechanism as you have just described, then termination doesn't come anywhere in it. So even if there had been a breach, they couldn't have called it a material breach and been able to terminate.
Yeah, the judge didn't have much time for the supplier's claim that wasn't a commercial interpretation, did he?
No, he didn't, because, and rightly, and you often see this in cases, commerciality is an important factor in the interpretation of contracts, but it is as at the date that the contract was entered into. And as we all know, truth can be stranger than fiction. All kinds of weird and wonderful things can happen within contracts that the parties at the time they entered into the contract had not envisaged. The judge's job is to decide what a reasonable person would have understood the contract to mean at the time it was entered into. And what may appear to be slightly uncommercial when the weird and wonderful happens doesn't mean to say that risk allocation for the unknown, I don't want to sound like Donald Rumsfeld and talk about unknown unknowns, but that is the point. You have to interpret it as in an objective manner, but as at the date of the contract.
Yeah, so because of trial, of course, you have the benefit of hindsight. So what? You're not meant to be bringing that, are you? You're meant to say, did this make sense at the time they signed the contract? And this clearly did. It's so well, I mean, it's a really well drafted contract, isn't it? Which is unusual. So
there's another element, which although academic, because as we just described, the judge found there was no breach, but there was a bit of another piece of very clever drafting in relation to the termination provisions, the consequences of termination provisions, which you see quite a lot in contracts. And David, did you find that bit interesting? Because it was quite unusual, wasn't it?
Yeah, definitely. So the judge went and looked at the consequences of the termination clause. Now, when you're drafting a contract, you're starting to glaze over a bit when you get to that clause. It's the clause that says if this contract is terminated, it's terminated, and the confidentiality clause will continue to survive, and you'll pay the invoices and all this kind of stuff. And you don't really think too hard about that. You've already done the hard work in drafting a contract by that point. And there's usually a bit of boilerplate in the consequences of termination clause that will say something about clauses that survive termination. And there's lots of different ways people do it. Sometimes they list the clauses. Sometimes they just say any clause that expressly or implicitly survives termination. And so what's interesting about this case is the judge went and looked at that clause and noted that this particular clause referred only to those expressly stated to survive termination. So it didn't have or implicitly, it just had expressly. And the judge said, well, if in this case the supplier had a good reason to terminate and had done so, then that means the minimum order quantity shortfall language wouldn't survive because it wasn't expressly stated to survive termination. And therefore, if that had happened, so lots of ifs now, haven't we? If there had been a breach, and if that had allowed the supplier to terminate, then having done that, if there was a shortfall, they could have sued in damages because the shortfall wording hadn't been expressed to survive termination. And I read that with sort of a slight alarm bells because I was thinking, oh, I usually glaze over and do I really properly check that I've listed all the right clauses? Of course, what you normally see is a list of clauses or any other clause that implicitly survives termination. And if this contract had that wording, it would have had a different comment from the judge.
Yeah, I suppose actually thinking about it, although the claimant lost because there had been no breach, it couldn't terminate. This particular clause works in its favour, or at least potentially, because the way the judge interpreted it, because that sole and exclusive remedy, the mechanism for payment of a sum, if that fell away as a result of the termination, then the claimant could have claimed just general damages, and those losses often are much greater than a set sum.
Yeah, so interesting, but the customer survived for another day. So from my point of view, Andrew, the issues that I think is interesting in this case is, if you've got a contract with minimum order quantities, do draft to say what happens next. In this case, it was drafted well and properly, and it worked. And in particular, those words sole and exclusive remedy worked. And then the other thing I've taken as a drafter is the survival point that we've just been talking about, that when you list out the clauses that survive termination, add on, and those clauses that are implicitly stated to survive termination. In fact, that implicit might well just rescue in a dodgy situation. So those are the 2 points I take from it. What are the points you have for it?
I think my main ones were on termination. Although it was somewhat academic in this case, I think it was a very useful reminder that if you think that you have a right to terminate, you've got to think very carefully. It's the reservoir dogs point I was making before. If you get it wrong, it goes horribly wrong for you. So you've got to take stock, you've got to think about it. Dare I say it, take legal advice before you make that decision. And then the second point would be, once you've decided, if you've decided to terminate, make sure you get the termination notice right. It is a minefield, frankly, in terms of making sure that you cover off the way that you want to terminate. There's this repudiatory breach point, then there's a termination under the clause of the contract point, or better still, as the judge suggested in this case, why not do both, one in the alternative to the other?
Great. We've also got a client alert on this topic. It's on our website if you want to read and understand the case. Thank you very much for listening to this Commercial Contracts podcast. And if you enjoyed it, you can subscribe to our newsletter and other podcasts on our website. Thank you.
Thanks for joining Gowling WLG for this podcast. If you enjoyed this episode, be sure to check out our website at gowlingwlg.com for more useful insights and resources. And don't forget to subscribe to ensure you join us for our next episode.